Good afternoon all. I am Jayashree from iOS. We are doing the CPC and we'll be continuing with Order 6 today. Okay. Order 6, the heading is Pleadings Generally. Okay. Pleadings. Rule 1, pleading. So what do you mean by a pleading? Anything by which you plead, you ask, you pray. That is known as pleading. Okay. But here we are not talking about the English meaning of pleading. Okay. What we are speaking about is the law. Okay. So what does CPC say about pleadings? From this, Order 6, Order 7, Order 8, all these deal with pleadings. So Order 6 is pleadings generally. Okay. Now we go to Rule 1, pleading. Pleading shall mean plaint or written statement. That's why I told you Order 6 means, Order 6 includes, it speaks about Order 7, Order 8. Why is it so? Because Order 7 we speak about the plaint, right? Order 8, written statement. So Order 6 is the basis. So what is pleading? Pleading shall mean plaint or written statement. Rule 2, pleading to state material facts and not evidence. See, when we are writing down the pleadings, whether it is the plaint or the written statement, we are not going to give any evidence in that particular plaint or written statement, which is together called as pleading. Okay, so we will use the word pleading. Pleading, we are not going to give out any of the evidences, except, of course, all of you are practicing, so you will be knowing when we are writing down the plaint or the written statement, we say so and so document has been attached or whatever it is as annexure A, annexure B, annexure C. This is how we write, right? But we don't describe what is there in that particular. So we are not talking about evidence in pleadings. We are talking about the material facts. What do you mean by material facts? We have already done that in the Evidence Act. Okay, material facts are those facts which are essential, important for the facts. Okay, so whatever is actually the relevant facts, whatever are the supplemental facts which relate to the main facts in issue, these are known as material facts. Okay, so Evidence Act, we cannot skip it, so I will tell you. When we say material facts, it includes the facts in issue as well as the relevant facts. Am I right? Facts in issue are the main facts, whereas relevant facts are those facts which are for the which are in relevant to the main facts in issue. Okay. So when we say relevant facts or when we say main facts, we say it's the facts in issue and the relevant facts. Okay. So pleading should to state the material facts and not the evidence. So when we say it is only the material facts, whatever is essential for determining the case, those facts should be put forth. It should be helpful in determining the case effectively. Okay. In that subrule 2, okay, we will read subrule 1. Every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense as the case may be, but not the evidence by which they are to be proved. This is what I told you. It will be only the material facts, those facts, whatever has happened because of which we are filing the case. So what does material facts contain? It contains the basis for the filing of the case, on what grounds the case is filed, for what reason, the cause of action. Am I right? The cause of action for which the plaint is filed, okay, the suit is filed. Everything will be written down in the plaint, in the pleadings. Subrule 2, every pleading shall, when necessary, be divided into paragraphs numbered consequently, each allegation being, so far as it is convenient, contained in a separate paragraph. See, we know essay writing, am I right? So whatever are the relevant facts, whatever are the connected facts, we don't say relevant facts, we will say connected facts. Whichever facts are connected, we try to put it in a series. Am I right? on so and so date this is what happened, because of which this happened, because of which this happened. So it should be sequential, right? It should be sequential and it should be paragraph wise. Okay, you can see the judgment writing video as well. So that is you have to follow more or less the same thing when it comes to drafting of pleadings. Okay, then next, dates, sums and numbers shall be expressed in a pleading in figures as well as in words. See, this is very, very important. Why? Because especially when it comes to all these material facts and what is happening, what has happened, and what's the prayer, it is very, very essential, especially in recovery of money cases, or when we are writing down the amount of damages that we are seeking from the court, whatever it is, whenever figures should be written down. When I say figures, it is numerics, correct? 1, 2, 3, 4, 5, 6. So whenever we have to write the numericals, what is important is we have to bring in the wordings. If I am saying, I am going to ask for 50 lakh, kindly grant me 50 lakh compensation. Okay, if I write 50 over there and then write a lakh, or I write 50 plus 0000, whatever the number of zeros, right? So if I am writing 50 lakh, I should immediately put it in words. Rupees 50 lakh only. If I am writing the date 26/11/2010, okay, if I am going to write 26/11/2010, then there are chances that there may be a mistake. So in order to make it a very make it very sure for the court, what do we write? We say 26 November 2020 or 2010 rather, right? So that is how it has to be written. It will make it easier, that's all. There's nothing else to that. If at all we are making a mistake in the numerics, some of us are in, sometimes it may be in a very urgent state that we are filing the case, or maybe the affidavit what we are filing has been done in 2 minutes time, something like this. So when we are writing in words, we'll be more conscious. Clear? So it is always better to put the dates or sum or amount in words. Next we go to rule 3, forms of pleading. The forms are in appendix A, when applicable and where they are not applicable, forms of the like character as nearly as may be shall be used for all pleadings. What they mean to say is the format. Clear? So forms of pleading, the format has to be necessarily followed. See, there is no particular format. If you have to take recovery of cases, recovery of money, this is how you have to write. There is nothing like that. Sure shot format is not there, but there are certain rules of drafting which we should know. Okay, so whatever is there in appendix A, you can just go through that and then keep it in mind. That's the format for pleadings. Rule 4, particulars to be given where necessary. So wherever there is a need to give a specific information. See, if I am saying, for example, you can take the cause title, that's the easiest one, am I right? So if I just say Jayashree, Bangalore, okay, in the cause title, suppose I write Jayashree, Bangalore, is that enough? There may be thousands of Jayashrees in Bangalore. How will anybody get to know which Jayashree? Right? So what I should say? Jayashree, so and so address, correct? And then I should say defendant, plaintiff, and all those things. Same way. So same way, whatever are the necessities to be given. If I am writing about say if it is a recovery of money case, sorry, or if it is a case about property repossession or whatever you want to take, you can take. So if I am talking about a property, then if I just say I have a property in Bangalore, my client has a property in Bangalore for which the suit has been filed, is that sufficient? Of course not. We should identify the property, right? It is situated in so and so place, having so much measurement, this is the boundary of the property, right? All those particulars should be needed, so that then not only will the facts become material facts, it is not only that it will be a genuine one, not only for that, but it will be easy for identification. Clear? Then next, rule 5, further and better statement on or particulars. This particular rule has been omitted. Okay, further and better statement or particulars, this rule has been omitted. Then we go to rule 6. Condition precedent. What is a condition precedent? Any condition which is already existing, that is known as condition precedent. So this particular rule deals with condition precedent. I mean, if you have done the Contract Act, probably you will remember a little about this condition precedent. So you can see everything is a contract, right? So you just keep it in mind and then you can write down the essay answer. Any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in the pleading by the plaintiff or the defendant. Okay, as the case may be, and subject thereto an averment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleading. So what is a condition precedent? An existing condition. Okay, see, everything is a contract. Almost everything is a contract except the family matters, right? Other than that, everything is a contract. Okay, so when we are filing a case, when we are writing down the cause of action, when we are writing down the material facts, what are we doing? See, this is the condition which was existing between me and the defendant. And this is what the defendant has done. So he has bet the reason for the condition itself. He has bet the condition. He has not followed it. There is a breach. Am I right? So there is a breach of condition which has led to the breach of the contract. Therefore, this is the condition precedent. Correct? This is the condition which is already existing. The defendant has breached the condition which is already existing. Therefore, when I approached him, he didn't give any reply. Therefore, I am approaching you for relief. Correct? So, there is a condition which is already existing, which is known as condition precedent. That is the material fact. That is the cause of action for which suit is filed. Clear? Then, Rule 7. Departure. No pleading shall, except by way of amendment, make any new ground of claim or contain any allegation of fact inconsistent with the previous pleadings of the party pleading the same. So what does it say? We cannot depart. We cannot go away from what we have already stated. It can either be in the previous suit, or it can be, see, if I am filing an appeal on behalf of my client. Okay, I cannot go away from the existing facts. We have already done the condition precedent, am I right? So I cannot go away from the existing facts based on which I had got the judgment of the lower court. So when I am filing the appeal, I have to write down exactly the same, unless there has been some additional facts which has occurred after the judgment has been delivered. Clear? So, or in between, when the case is still existing, when it is still being proceeded against in the court, leads pendants, am I right? Suppose the case is still pending before the court and there are certain changes in situations. Even then, that has to be written down in the pleading, provided we get the permission from the court. Clear? So for that, how do we get the how do we get the permission from the court? We have to file an application for amendment, and if the court sanctions, of course the opposite party objections will be there, and once the court says okay, we can amend the pleading. Okay, only then whatever are the new facts or changed facts or whatever, everything can be included. We go to Rule 8, denial of contract. Where a contract is alleged in any pleading, a bare denial of the same by the opposite party shall be construed only as a denial in fact of the express contract alleged or of the matters of facts from which the same may be implied, and not as a denial of the legality or sufficiency in law of such contract. See, when there is a denial, okay, so we know it, when we are writing down the written statement, we deny some of the facts. Am I right? So when we are denying the facts, it doesn't mean that the contract itself is being denied. Not like that, okay? But there has been denial of the allegations. See, when I'm writing the written statement, I will say, yes, it is true that I had entered into a contract with the plaintiff on so and so date. Okay? But these things happened, so I could not do my work. Okay? So there is only a denial of the facts, not the denial of the contract itself. Unless I am specifically denying the contract. If I am specifically denying the existence of the contract, then that's a different thing. Okay? But just because I am denying all the allegations put forth by the plaintiff doesn't mean that I am denying the existence of the contract itself or the validity of the contract itself. Unless I tell openly, unless I am very express about it that the contract is not valid or there was no contract at all between me and the plaintiff. Okay? Then rule 10, malice, knowledge, etc. Wherever it is material to allege malice, fraudulent intention, knowledge or condition of the mind of the person, it shall be sufficient. This is not a criminal case, therefore. It shall be sufficient to allege the same as a fact without setting out the circumstances from which the same has to be inferred. See, I already told you, it's not a criminal case. In criminal case, you have to establish that this is the act which led to the malice or the wrongful intention, right? Or the wrongful, wrongful knowledge or wrongful intention or fraudulent intention. These are the circumstances. Therefore, fraud case is filed. No. In civil cases, even though we are alleging malice or fraudulent intention or whatever, just mention it as a material fact. Therefore, the defendant is said to have acted with malice, with fraudulent intention. There is no need to mention exactly the circumstances which has led us to believe that there is a fraudulent intention. Clear? See, for example, if there is a contract and the defendant has committed breach of contract. Okay. Now, when the defendant has committed breach of contract, obviously we will just say, he had a fraudulent intention, therefore he committed the breach. But do we do anything about it? No. It's just a matter of fact that I am writing it down there. Right? That's all. Then, Rule 11, notice. Wherever it is material to allege, notice to any person of any fact, matter or thing, it shall be sufficient to allege such notice as a fact, unless the form or the practice terms of such notice or the circumstances from which such notice is to be inferred are material. So, we send a legal notice, am I right? It is not that notice that we are talking about. Wherever we need to show that the other person has committed something, then what we do, unless it is very serious and we are basing our criteria on that, are basing our suit on that criteria, then we have to write down everything. The other party should have the notice of whatever we are doing. Otherwise, it is not necessary. Then, Rule 12, implied contract or relation. Whenever any contract or any relation between any persons is to be implied from a set of letters or conversations or otherwise from a number of circumstances, it shall be sufficient to allege such contract or relation as a fact. Okay, and to refer generally to such letters, conversations or circumstances without setting them out in detail. And if in such case the person so pleading desires to reply to the alternative upon more contracts or relations than one as to be implied from such circumstances, he may state the same in the alternative. So wherever there is a written contract, okay, it shall be written down. If there is an implied contract, that shall also be shown. Shown in the sense it shall be shown as an implied contract. Okay. It shall be sufficient to allege such contract. Okay, whether it is implied or express contract, it is sufficient if it is written as a matter of fact. Not matter of fact, as a material fact. Okay. And it is in such case the person so pleading desires to rely in the alternative upon more contracts or relations than one as to be impleaded from such circumstances. So wherever there is a need to write down about the express contract or implied contract, it shall be written down as a material fact unless it has to be specifically described. Then it shall be described. Rule 13, presumption of law. Neither party need in any pleadings allege any matter of fact which the law presumes in his favor. See, when we again we go back to the Evidence Act, I can't help it. Okay, so again we go back to the Indian Evidence Act. We know some presumptions. There are shall presume and may presume. I hope you are aware of that. You must be aware of that. Shall presume and may presume. Am I right? So there are certain things which the court shall presume. So we need not write it down in the suit at all. We need not do it in the drafting at all. Right? But there are certain facts which the court may presume and hence we have to write. Like how we saw in the previous rule. Am I right? Implied contract or relation. Where it is necessary that we should show the implied contract or relation which is existing, there we have to write it down as a important fact, as a material fact. But where it is a shall presume position, then we need not give any explanation about it. Right? There is an express contract. We can just say I had gotten into a contract with the defendant on so and so date for this purpose. That's enough. I don't have to show any implied contract or implied relation between me and the other person. Why? Because the court itself shall presume. If I have an express contract, then there is an implied contract as well for certain duties and rights. Am I right? So that is what we is given in the Rule 13 as to presumption of law. So whatever comes under shall presume need not be written down. Right? So it shall be presumed by the court, saying that, okay, since there is a contract, there is a existence of a claim by the plaintiff against the defendant. I don't have to specifically write, no sir, since I got into contract, I have a claim over the defendant. Should I write it? No. Okay. Rule 14, pleading to be signed. We know it, right? Every pleading should be signed by whom? By the party, by the advocate. Anyway, signed by the party and the pleader, if any, provided where a party pleading is by reason of absence or for other good cause unable to sign the pleading, it may be signed by any person. So whom, again we go back to the summons whatever we did, right? So party will sign, party should sign, advocate should sign, but if the party is unable to sign due to any valid reason, the authorized agent can sign. Okay, that's Rule 14. Then we go to Rule 14A, address for service of summons. This is very important, right? Because nowadays no suit is accepted unless you give an affidavit, application and affidavit saying that this is my address. Correct? So, address for service of notice. Wherever there is an address, of course, all of us have addresses. So, when we write down the address for the notice, we should also give an affidavit along with the application saying that truly this is the address for the purpose of service of summons, notice, etc. Whatever correspondences the court would give. Okay. Then Rule 2. Such address may from time to time be changed by lodging in court a form daily filled up and stating the new address of the party and accompanied by a verified petition. Verified petition means what? First you have an application, then you have the affidavit. Okay, if the address changes in between, then again we have to file an application saying that my address has changed and this is the affidavit towards it. Okay, verified petition means affidavit. Affidavit should be there along with the petition. Okay. Then rule 3, the address furnished in the statement made under sub rule 1 shall be called the registered address of the party. Why? Because the party will have a specific address. See, if it is a company, we say the registered office is in so and so place. Then we say duly represented by its branch office in so and so place, right? So they, again, when we are writing about individuals also, we have a particular address. So that should be written down in the plead. And that is known as the registered address. The address that we know, that is known as the registered address. Rule 4, sub-rule 4, service of any process may be effected upon a party at his registered address in all respects as though such party resided thereat. So, service of any summons or notice, everything shall be given to that particular address. Sub-rule 5, where the registered address of a party is discovered by the court to be incomplete, false or fictitious, the court may either on its own motion or application of any party order in the case where such registered address was furnished by a plaintiff stay of the suit. Where the particular address has been furnished, it is either false or it is either invalid or incomplete or fictitious, then the plaintiff's suit shall be stayed. Why? Because the defendant's address is not there, right? And if the defendant doesn't stay there, or if it is a fictitious address, then how will the courts give the summons, serve the summons? Not possible, am I right? Therefore, the person cannot, the suit shall be stayed by the court. In case where the registered address was furnished by a defendant, his defense be struck out. If the defendant says, no, plaintiff doesn't stay in this place, plaintiff stays in so and so place, if he gives a wrong address, then his defense shall be struck out. So whatever written statement he is filing, it shall be struck out. Then sub-rule 6, where a suit is stayed or a defense is struck out under the sub-rule 5, the plaintiff or the case may be the defendant may, after furnishing his true address, apply to the court for an order to set aside the order of stay, or once the correct address is filed, if it is the plaintiff, he shall order to vacate the stay. If it is the defendant, then he shall file an application to vacate the order for striking out of the defense. Sub-rule 7, the court, if satisfied that the party was prevented by any sufficient cause from filing the true address, it shall set aside the order. See, if it is true, the plaintiff doesn't know the present defendant's address, the defendant's present address, clear? Or defendant doesn't know the present address of the plaintiff. If it has been done bona fide, that's the easiest way of saying. If it has been done bona fide and the court is convinced that it has been done bona fide, then the court can strike the order. Sub-rule 8, nothing in this rule shall prevent the court from directing the service of process of any other address. If there are more than one addresses, then process shall be, that is the summons shall be issued to the address which we have shown already as a registered address, but which is fictitious or false, or we don't even know where the defendant is residing, right? In that case, the optional, that is the second address which we have written, the court can send to that place. So what will the court do? It will send to both the places. Clear? Then we go to section, rule 15, verification of pleadings. Verification of pleadings means what? We write a certain plaint or a written statement, okay? We have to verify that whatever we have written in the pleadings is true to the best of our knowledge. We think that it is true and correct. How much? To the best of our knowledge, to the best of our belief, to the best of our information. We have got this information, so we are telling you this. We have this knowledge, therefore we are telling you this. Clear? We'll believe that the defendant has tried to do this or has done this. Therefore, we are filing the pleading. So, every pleading should have a verification affidavit. Very, very important. Plus, the address that we have filed. Everything should be verified. That is why we have the verification of pleadings, which verifies whatever we have stated in the pleadings to be true and correct. Okay, in that rule 2, sub rule 2, the persons verifying shall specify by reference to the numbered paragraphs what he verifies. See, when we are writing the verification affidavit, what do we say? Whatever I have stated in paras 1 to 14, 1 to 24, whatever is the number, we specifically write down the paragraphs, right? We don't write 1, 2, 3, 4, 1 to 24, 1 to 30, that's how we write. Sub-rule 3, the verification shall be signed by the person making it and shall state the date on which and place where it was signed. So, verification pleading shall be, verification affidavit shall be, verifying affidavit shall be signed by the party who is making it. The date and place shall be specified there. Sub-rule 4, the person verifying the pleading shall also furnish an affidavit to support his pleadings. Okay, so that's what it is, verifying affidavit. So when we are verifying the affidavit, verifying the pleadings, the affidavit shall contain all the details about the pleadings and it shall be signed. Okay, then we go to rule 16, striking out pleadings. The court may at any stage of the proceedings order to be struck out or amended any matter in any pleading which may be unnecessary, scandalous, frivolous or vexatious. See, we have already read that there should be material facts in the pleadings. Irrelevant facts should not be there. We have already read that there should be facts in issue, relevant fact and cause of action. Am I right? And what is a prayer? Unnecessarily, we should not include any unnecessary points or fictitious points or very small reasons. Frivolous or vexatious means what? Something which is very small. Suppose I am filing for divorce. If I say no, my husband does like this and I give a very small reason. Very, it would not be right to use the word, but I'll just use the word very silly reason. Okay. It is not only a family matter, even if it is for recovery of money. Say for example, some person has to pay me 100 rupees as interest per month. And that person, 1 month he has not paid me 100 rupees. Or say for that 1000 rupees or 1 lakh or whatever. But for that 1 month, and he has already informed me that he is not going to pay me for that 1 month. Right? He said I will pay both at the later stage, that is in the next month. But still what I do, I go to the court and say, sir, I have to get 1 lakh this month, I am not getting it. And then what will the difference